Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandal and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back. Thank you for joining us for Speak Up. Today we have a special case, a different case, one that's gone to the Supreme Court or is filed with the Supreme Court here in New Hampshire. His case is a very special case because it's completely documented. Something keeps going awry. Something is wrong. Something is very wrong with some of these cases that are coming before Speak Up. This person has not yet filed a petition with the Redress of Grievances Committee, but plans on it, and was warned not to at some point because it could hurt his case. Why? Aren't we all here looking for the truth? Something has to be done. I want to introduce my next guest, Mr. Joe Kenick III. Thank you for coming on the show, Joe.
Thank you very much for having me.
Okay, now I'm looking at all this paperwork and I'm thinking, wow, you came prepared for the show.
It is. Unfortunately, litigation in the family court system in New Hampshire is paperwork intensive.
Okay, now you're an appellant to the Supreme Court?
I am. I have a case pending in the New Hampshire Supreme Court right now. It has been accepted.
All right, well, let's get started. You have an interesting story. You know, starting from your divorce, I mean, you can go wherever you want, but you know, let's get started with this. What happened? You got divorced. It was a nasty divorce?
It didn't start out that way. She filed for divorce in 2008.
Okay.
After 7 years and 11 months. I didn't break a single marriage vow or anything. She just had met someone else and decided she wanted to be somewhere else.
Okay.
So I was hoping that it could be amicable and over relatively quick, especially since we have young children, but unfortunately it has...
How many children do you have?
Two.
Two. Boy and a girl?
Boy and a girl, yep.
Okay. How old are they, if you don't mind me asking?
They were 6 and 4 when this nightmare started, and they will be 11 and 9 this August.
Well, right off the gun, and I didn't ask you this off camera yet, so how often are you seeing them?
I saw them 3 hours total last month.
Okay. Do you have a criminal record?
I do not.
Are you a violent person?
I am not.
Have you ever been convicted of hitting her or the kids, any child abuse or anything like that?
I have not. As a matter of fact, she's had me arrested 3 times, and I've been found not guilty on all charges.
Okay, so
let's stand before you with absolutely no criminal record of any kind.
And the children are how old? They
will be 11 and 9 this August.
And you see them how much?
3 hours last month.
And how long has this been going on? Has it been like...
Since Marital Master Cross's ruling of October 4th, 2011, which is the day that Judge Kelly moved this case from Portsmouth back to Brentwood.
All right, let's go from the beginning. You're divorced. Take us from there.
She filed for divorce May 1st of 2008. My company closed, the employer that I was working for closed the company in September of 2008, which led to all sorts of financial and emotional harms. And the family court at the time had stated that they wanted the case concluded as early as possible, and the earliest dates we could get at that time was April 8th, 9th, and 10th of 2009. So this case was supposed to be concluded at that time.
Okay.
Unfortunately, my ex-wife changed lawyers and got the entire case postponed from April 2009 to some indefinite period. So the Portsmouth Family Court moved the entire case to the Brentwood Family Court, which shockingly was like a giant do-over. They just eliminated everything and said, we're sending the whole thing over there, they can adjudicate it.
So all the money that you spent, all the time that you put in this process, did you have a GAL at that
I
point?
did not.
Okay.
The court repeatedly stated that neither party could afford a GAL and that none was necessary in this very simple divorce. It is a relatively simple divorce.
Any mediation in that, in the first hearing?
There is not. The Brentwood court ordered mediation in April of 2009.
All right, so you had, your first hearing was supposed to be ended, and then she decided to get a new lawyer? Or?
To change lawyers, which somehow postponed the final hearing.
Right.
And to an indefinite period. It was going to be in August of 09, and then it was going to be in October of 09, and then the Portsmouth Family Court said, we can't adjudicate this in a timely fashion, and they sent it to the Brentwood Family Court, which apparently had more capacity at that time.
Were you seeing your children before the first
I
hearing?
was. I had 50% custody of my kids until Marital Master Cross changed that in 2010.
Were you paying child support before Marital Master
I was paying it until my company closed, and then I did not have to pay it until I was reemployed.
Okay, so now take us from Marital Cross.
So Marital Master Cross and Judge DeVries remanded the case from the Portsmouth Family Court to the Brentwood Family Court, where we held one hearing, April 1st of 2009, and before Marital Master Foley. And Marital Master Foley said, I'm only going to hear one issue today. It's Ms. Kenick's complaint with regards to telephone calls and nothing else. He said everything else we'll handle at a pretrial, which we'll schedule after this. She didn't like his ruling, and it's public record. In fact, it's in
what was
his
his
paperwork.
ruling?
He ruled that her obsession with telephone calls was detracting from her intuitive value as a parent. She didn't like that, so he ordered us both to mediation to take the children out of this divorce. I said, make the 50-50 parenting plan permanent. It works just fine. I agonized to create it, and the court endorsed it. So
that's documented.
That is documented. Yep, it's in my proposed parenting plan, and the court endorsed it in June of 2008.
The court endorsed it. It's documented. 50-50 parenting.
Correct.
Game over.
You would think so. Unfortunately, we were then ordered to go to mediation, and she refused to show up, which you'd think is in contempt of court. You can't deny, you can't just ignore court orders. Well, apparently she can, because I filed for a contempt of court motion, and that is documented with a lawyer, as a matter of fact, because I wasn't confident enough to do it on my own yet. And the court said that it would hear it at the upcoming pretrial, which was then scheduled for September of 2009. Right before the pretrial, she changed lawyers again, which bumped the pretrial out from September to November of 2009. That's her third lawyer.
Aren't the judges getting sick of this? I mean,
you would think so, but unfortunately, over my objection, the court just kept granting delay after delay after delay. And that's what's so frustrating about this process. It's a simple divorce. I don't have a vast amount of stocks or bonds or anything. It's a house and 2 children. She can't have my house, and she can't have more than 50% custody of my children. That is the divorce. And that has got me 48 months of litigation.
When does it break down that you're not seeing your children?
After she postponed the September pretrial to November, she then changed lawyers again in October and bumped it out to December, by which time Marital Master Foley was no longer at the Brentwood court. He'd been moved to Dover, I believe. And therefore, the Brentwood Family Court said we've only had one hearing all year and sent the whole case back to Portsmouth, which I have to bring up to you. Justice delayed is justice denied. This case is an embarrassment to American jurisprudence and a travesty of justice. The entire time this is happening, she's seeking to create altercations. She's refusing to transfer custody of the children. Then she trespassed on someone else's property, and I have a notarized affidavit from the man in here who came 4 times to testify to court, and Marital Master Cross wouldn't let the man speak, ever. He never got to testify. That's why he wrote a notarized affidavit, and that's public record.
That's what I had before.
To obtain a restraining order. The minute she obtained a restraining order, now I can't be much of a threat to her if she seeks me out on property where she has no legal right to be, and I don't touch her or harm her in any way. I just told you I've never touched my wife, ever.
Okay, so she gets the restraining order on you.
Correct.
And then does that change the whole
picture?
It does, by a bunch, just like it did in the Ruggiero case, which made all sorts of headlines last year from Brentwood.
Quickly, what was that all about?
Jeff Ruggiero was wrongly accused of violating a restraining order. His wife had him arrested. The man nearly lost his job in the U.S. Coast Guard.
Was he in the military?
He is in the U.S. Coast Guard.
Okay.
And then it was later found out that she was texting herself threatening messages. She was incarcerated and just died of a seizure in December of 2011. However, you would think Jeff Ruggiero must get his children back, right? He still doesn't have custody of his daughter. In fact, his comments were written up in the statewide newspaper.
Okay, and now getting back to your case.
So just like that, it's a game changer, and I think that's why they're sought after.
What, the
restraining orders? Restraining orders are a game changer. All of a sudden, the GAL, which had been repeatedly stated by the court was not needed, is ordered. All of a sudden, the children are off to counseling. After repeatedly stating that the court saw no need for counseling and the children didn't need to be there, and all of a sudden, she's able to repeatedly obstruct custody. Custody transfers, the 50-50 parenting plan gets significantly more difficult to work, but we kept it in place. The 50-50 plan was still there. So then the case gets remanded back to the Portsmouth Family Court in January of 2010. And the court immediately orders a final hearing for September 9th and 10th. Now, you don't have to be a mathematician to realize that when this case was only 8 months old, it was going to be a 3-day final hearing. And now it is nearly 28 months old, and it's going to be a 2-day final hearing. I wrote to the court, I said, how does that make any possible sense? By that point, we had several hundred motions. I'd been rendered pro se by all the delays in the court, so I had no lawyer. And I've been doing this on my own ever since.
Will a lawyer take your case, or
They will for a significant fee. In fact, there are now 576 motions in my case. I spoke to a lawyer who recently stated that it would take $10,000 minimum just to get caught up to where my case is. So no lawyer would take this case at this time. I did try lawyers on a limited representation basis for a short period. The difficulty with that is that your lawyer doesn't know your case. In fact, you know your case far better than your lawyer does. They don't have enough time to pour through the mountains of paperwork.
I can see that.
Yeah. And I should explain what these are. This is certified transcripts. You cannot have a case in the New Hampshire Supreme Court without certified transcripts. This is 3 days. This is 900 pages of 3 days of court hearings. Mm-hmm. This is my brief, not very brief. This part is the brief. This is the supporting documentation of which I've referenced. In New Hampshire Supreme Court, I do have a pending case before the Supreme Court. It has been accepted under Mandatory Rule 7.
Okay, take us to where we're at this point before your appeal to the Supreme Court.
Sure.
Okay, so now we have a guardian ad litem involved.
We get a GAL involved. We get counselors for the children involved. In fact, the same counsel that was repeatedly rejected by the court had been litigated by my lawyer repeatedly, saying anybody but her, but under no circumstance can this woman be brought in. And she had been introduced by my ex-wife in 2 separate capacities. One, she wanted them for counseling, and one, she wanted them for parent coordination.
How are the kids going through this? What's going on now with them?
That's an absolute travesty. The children at this point are becoming incredibly frustrated in that they're not allowed to see their father. They're not allowed to go on vacations. She's obstructing custody transfers. They're begging to come live with me. Unfortunately, they were actually physically assaulted. According to my son, he was smacked around for saying he wanted to come live with me. And I have a notarized affidavit, or I wouldn't even tell you this, from a former attorney in the New Hampshire Attorney General's office. And he wrote me a notarized affidavit saying, I attended a court hearing, and the GAL admitted on the stand that she did not investigate any of the children's specific complaints of abuse. Not one. How can that happen? But it does. If I didn't have it documented, I wouldn't tell it to you because I wouldn't believe it myself.
Is the guardian ad litem taking sides?
The guardian ad litem at that point was ordered to work for $60 an hour, not to exceed $1,000.
Okay.
I said, that works for me. I sent my $500 in for my half of the $1,000 cap. I said, do your thing, go talk to my children, please. She then sends me a contract. She's an attorney as well. Sent me a contract for $140 an hour, not to exceed $9,000. Now, that's a 250% increase over the hourly rate ordered by the court, and it's a 900% increase over the cap ordered by the court. I was then forced to say, I can't possibly afford this, and I filed a motion with the court saying, make her work for the $60 an hour you ordered her to, not to exceed $1,000, or give me a new GAL. So the court ordered Attorney Jen Rackley to work for the $60 an hour. She came and interviewed me and my children at my house, and then Sarah...
I got to stop you. So the GAL is an attorney.
Correct.
Who is not going by statute or of $1,000 per case.
That's right.
And that's legal?
Apparently, if I had signed the contract, yes, it would have been. But I said, I'm not signing that contract. I want the court to uphold its ruling, and it did.
Okay, so the court didn't force you to sign that contract.
That's correct, it did not.
Okay, so now we got a new GAL.
No, the same GAL. The court ordered her to work for not the $140 an hour she was demanding, but for the $60 an hour they ordered her to work for.
Oh, okay.
Which certainly didn't endear her to me at all. Or me to her, I guess.
Right, that obviously puts you at odds right from that point on.
Correct. From the very moment she was ordered.
I see. All right.
So then she was supposed to have her report done by August of 2010, because the final hearing was scheduled for September 9th and 10th of 2010. She files an extension and then asked of the court if she could exceed the amount, the $1,000 cap, and the court granted it. Now the sky's the limit. Here's a blank check. Write yourself whatever you want. She then called the 3 people that I had given her the week before the final hearing. She writes her report September 1st. I receive it September 2nd, 7 days before the final hearing. It's in here. It is not public record. It is sealed. However, I wrote a motion to the court quoting it verbatim directly from the GAL report. On page 9, it says she wants to live with her father, and here's why. My son Joseph says he wants to live with his father, and here's why. The children complain they've been hit and threatened because they want to live with their father, and here's why. They've witnessed assaults upon me and none from me, and they want to live with their father, and here's why. All of those, that is public record. The motion to the court is public record, and in fact, it is part of the appeal to the New Hampshire Supreme Court as well. It's in my appendices. And
we're going to stop and take a break right now, if you don't mind. We'll be right back. This is a public service announcement about judicial child abuse, and I have with me Josh Youssef, the founder of Judicial Child Abuse. Welcome to the show.
Thank you, Kevin.
You're the founder of this program, and I want to know a little bit more about it and how the listeners or followers of this show can get in touch with you.
Sure.
So what was the impetus of judicial child abuse?
Well, about a year ago, I found myself in the unenviable position of having to try to get my son back, who was taken from me unlawfully by the New Hampshire Family Court. I thought that I was the only person in the world that had his son taken unlawfully. I didn't know where to turn, left or right, north or south. I didn't know where to go.
You thought you were the only person that was going through this?
That's correct. I had no idea what was going on in the family court system. So the first place I turned was the internet. And I'm looking for groups of people that had been dealing with similar situations so that I could at least see if I was the only person in the world that was going through this.
And you found?
I found a lot of men's rights groups, women's rights groups, some grandparents groups, just different types of organizations that were centered around a particular subdivision of the family, like a father, for example, a father's rights group. And unfortunately, I came to the reality that there was no group that was formally organized which would bring the news about the abuse that children and families are suffering at the hands of the New Hampshire family courts. Now, it's not just the family courts. It's governmental transparency problems as a general whole. Okay. Now, the Redress of Grievance Committee is an avenue that I've been pursuing. I'm petitioner number 26. And so as a result of the Redress of Grievance process, we have noticed an overwhelming number of people have come forward to Judicial Child Abuse, which is a contributor-based blog. I don't do all the authoring. I do some of the authoring, and other people who have come forward with similar stories or who have knowledge regarding a particular subject matter, such as the law or psychology or child development things of that nature, they've come forward and contributed articles and their knowledge. We have short video clips of interviews with litigants and with people who have had their children wrongfully taken away from them in an unlawful manner by the New Hampshire Family Court. And we also have a wealth of other information, and we look forward to populating the website with quite a bit more government transparency.
Real quickly, Josh, tell me about this fear factor that people are finding. They're either afraid of coming to the redress of grievance because their lawyers will be considered despised litigants or
Yes.
By the courts?
Yes. I found myself in the situation after I became a pro se litigant and I was representing myself. I fall into a category known as the despised litigant. A despised litigant, something I affectionately refer to myself as, is somebody that the court cannot tolerate on principle. You cannot win in the court system as a despised litigant.
Are you sure of this?
Well, in my personal experience, I'm 100% sure of it.
Okay.
I have pursued justice unrelentingly for an extended period of time, and I have watched the family court just breeze my pleadings, just breeze them right on by.
Getting back to the fear factor.
Yes.
How does this affect the public?
It's very difficult to obtain representation by a competent attorney or by an attorney with any sort of a reputation. And the reason is because they're all members of the Bar Association. They're all friends with the judges. And so when you take your case and you plead to the legislative branch of government in the Redress of Grievance Committee, you have now, I guess, stepped on the authority of the judiciary, and they become very, very defensive. As a result, attorneys are very loathsome to take on as clients any petitioner for redress of grievance.
So should people shy away from the redress of grievance?
Absolutely not.
Why?
This is a reason to push forward even harder, to expose the problems that exist within the judiciary. The judiciary in 1978 was given virtually a blank check by the legislature of 1978, and that is in the form of Part 2nd, Article 73A of the New Hampshire Constitution, which allows the Chief Justice of the Supreme Court to control the rulemaking authority of the entire judiciary. But the problem with that, at the end of that piece of constitutional legislation, says that the rules that are created shall have the force and effect of law. So as a result, what ends up happening is you have a single person, a single Chief Justice that has the ability to make rules, and those rules become law.
Hence, we have judicial child abuse.
Correct.
And if people want to get in touch with you, how do they do it?
They need to contact us by email at news@judicialchildabuse.com. If you have any bit of a story to tell, if you have an inquiry, if you're feeling alone like you're the only person in the world, or if your children or your family has been judicially abused by the corruption that exists within the New Hampshire Family Division, contact us.
Well, there you have it, folks. Judicial child abuse. If you're having difficulty and you find yourself in a spot where things aren't making sense, contact them at judicialchildabuse.com. This has been a public service announcement. And we're back with Joe Kenick again. Joe, let's continue the discussion. This is where the meat starts hitting the road here. We're getting into the meat of it now.
Absolutely.
As far as
Where the case has gone. So we finally get to a final hearing.
yeah.
September 9th and 10th of 2010. At the final hearing, the GAL changes her report from 7 days earlier and states that the children have repeatedly stated they want to live with their father, so therefore they should spend more time with their mother. I said, in what universe does that make any possible sense?
Say that again slowly, please.
The GAL reverses or rescinds her earlier report filed just 7 days early, less than 7 days earlier,
Right.
stating that the 50-50 parenting plan should continue. And instead states the children wish to live with their father, so they should spend more time with their mother.
I'm not sure. I understand that, but
Because I'm accused of parent alienation,
okay.
which if you have done anything with the studies, you'll realize is considered junk science by every major psychological group.
Is your X paying also half of the GAL or the guardian ad litem.
She's supposed to at that point. In actuality, neither of us were. It was paid for out of the state fund because neither of us could afford a GAL.
All right. And so there's funds for the GAL to go beyond the $1,000. There's funds somewhere for that GAL to tap into.
That's correct.
Okay.
And she's writing her own check for as much as she wants.
Is that just throwing this out there, is that the Title 40 money?
It is not. I'm very glad that you asked that. The viewers would certainly ask out there, how can this happen? Where is the advantage to the court? Why would they drag out a case? Why would they create disproportional custody awards? And it comes from Title 4D, which is part of the 1975 Social Securities Act. In it, as with many government programs, it was well intended. The government said, we have a lot of single mothers with children and they're on the welfare rolls. Let's get them off the welfare rolls by making the fathers pay. We can only make them pay by giving an incentive to the states to collect the child support they've ordered. Therefore, they implemented Title 4D. They said, if you, the state, can collect 60% of the child support you order, we will match it, matching funds. What it did in actuality, it did nothing to remove lower income single mothers and their children from the welfare rolls, but it created an incentive for the court.
An industry.
It created an incentive for the court to tap into federal funds using children as pawns.
I heard that Mondale said that this could possibly be abused. Is this what you're saying, that it is being abused?
It is absolutely being abused.
Interesting.
And unfortunately, the children, which you alluded to earlier, are the ultimate victims. They're the pawns in the whole thing because they're the key. By creating disproportional child custody, the court collects funds from Title 4D.
Are you saying that then the GALs have an incentive to prolong these cases in order to...
Only because the GALs are part of the judicial branch. It's really the judicial branch of government that benefits from creating disproportional custody, which is oddly enough why the lawyers and the GALs who are lawyers are opposing the attempts by the legislature recently, I believe it was Bill 591, which was going to mandate equal custody unless it was proven inarguably.
That was recently tabled by that committee.
Correct.
591. Yeah, they said that there wasn't a problem here and that California was basically adopting our statutes, our laws, because there's just a bunch of mad dads out there, and we have no reason to support this 591. But in actuality, it does support 461A11, which guarantees, unless there's a clear and convincing evidence of neglect, if equal parenting.
Kevin, you just touched on something very appropriate. The family court, unlike criminal court, does not follow any rules of evidence.
Rule 1.2, which says waiver of rules. This is why CACR 26 must pass. And this is where I'm going to get involved with our conversation because I know you want to speak up.
Yes, please.
This is my little platform right now to speak up because CACR 26 passed the House.
Already, and is in the Senate right now and must pass.
It's in the Senate and it must pass, and the reason it must pass is because that the rulemaking authority, which was once with the legislature,
which is an elected branch of government, by the way. You cannot allow the judicial branch to make its own laws or to legislate from the bench.
Right, but for our viewers, what happened in 1978, the legislature, in its wisdom, said to the judiciary, we're going to give you rulemaking authority, and such rules shall have the effect of law. Of course, that last line was never on the ballot, and people don't know that.
Correct.
So now, since 1978, since we fooled around with the Constitution, the judiciary has been making its own rules. And one of the egregious rules that seems to be popping its head up is Rule 1.2, which is, as far as rules of evidence, for good cause, we waive those rules and we can go with hearsay. Correct. All right. I'm off my banter. I want to just change the subject. Let's continue to go on.
I'm glad you brought that up because it's an important one. In fact, it's real important for the viewers to contact their senator and support CACR 26, because the balance of power needs to be restored to the people, and the people are represented by their elected officials, not by appointed people with lifelong terms who can make up rules as they go along.
Right. Now, May 3rd, that will be heard in room 101, I believe, at 1 p.m.
It will indeed.
Right. So if you're interested in this topic, please show up. So let's continue on with your case.
So the GAL changes her report from barely a week earlier, and states that the children wish to live with their father, and therefore they should spend more time with their mother. All that really did was allow the children to be brutally punished for what is published in her earlier report, stating why they wanted to live with their father. It was a 2-day final hearing, September 9th and 10th. So on September 10th, I showed up with more than a dozen witnesses to refute those arguments.
Mm-hmm.
In a 6-hour and 21-minute hearing, I got the last 25 minutes. That's all. No one was allowed to speak. I got her stepfather on the stand for the last 25 minutes, and I wouldn't tell you that if I didn't have a notarized affidavit from him as well in this packet. He also wrote a letter to the New Hampshire legislature about how appalled he was at what he personally witnessed, the injustice he witnessed in the family court that day. So it defies reason.
There is abuse going on. Are you saying there's abuse going on?
Absolutely, because in that hearing...
Is DCYF involved with this?
Not yet.
Okay.
But I'll get to that part of the story.
In this hearing, you have 25 minutes out of a 6-hour...
Out of a 6-hour and 21-minute hearing, I got the last 25 minutes, and that's all I got. Her lawyer stalled all day long, and if I didn't have it in writing to support it by people who are not family members, who were just taxpayers of the state of New Hampshire who witnessed this appalling atrocity,
right,
I wouldn't tell it to you.
Did you have a lawyer in this?
I did not. I was pro se.
So did you object?
I did repeatedly.
Okay. Your Honor.
It's in the certified transcripts.
Okay.
Time and time again, I'm like, when do I get to talk? When do you take my exhibits? He took none of my exhibits, A through DD, and he accepted none.
Okay.
And that's part of this. This is an atrocity of American jurisprudence. How can this happen in America? Yeah. And so Marital Master Cross then revoked my 50% custody and stated that I could have no more overnights with the children. Why overnights defies logic, but okay.
Based on what?
Based on the fact that the GAL had said they need to spend more time with their mother. He actually revoked all my custody and then gave back all but overnights a week later.
And there's no police report saying, hey, you know what?
Oh, none at all. Right. Nothing. There is no police report, no assault, no anything.
In fact, no threatening phone calls?
No threatening phone calls,
letters,
nothing
emails?
of any kind.
Interesting.
And yet the children are pleading for protection and relief.
Did you mention to the judge about 461A?
I did, as a matter of fact. It's in motions to the court, and I brought it up in testimony as well.
Would you consider yourself an undesirable litigant?
I believe that the court considers me so, absolutely.
Okay. Let's move on.
And the difficulty is that RSA 458 protects my home, but the legislature has already passed laws to protect me and my children. And RSA 461, which you just mentioned, actually lists 12 criteria with which the court is supposed to consider custody.
And 591 would have enforced that.
That's correct.
Interesting.
And instead, the court ignored them all. We don't care what the law is. We don't care what the Constitution says. We're going to do whatever we feel like. And that can't happen. It is vital to civilized society that jurisprudence be unbiased and impartial, and that the public perception of justice be that way. Otherwise, we fall into a realm where we don't want to go. In fact, it was brought up by Senator Taft back in the 40s, and you only have to review history to realize what happens when justice can't be obtained in a court of law. It is not good for society, for anybody, not for the taxpayers, not for the children, not for the litigants. It must be in a court of law.
Okay, so let's move on.
So my custody is revoked. A week later, I get to see my children during my 50% custody time, but no overnight. So my custody is reduced from 50% to about 11%, which creates all sorts of more custody transfers. Nothing changes. The children continue to plead to come live with me, at which time she then yanks them out of their scout groups, so they can't they can't go to Scouts anymore. I am a Scout leader. I'm an Eagle Scout myself from 1986, and I've stayed with Scouting ever since. And I was my son's den leader. I'm currently an assistant Scoutmaster in a local troop.
Okay, and so she pulled her out of Scouts?
She pulled my daughter out of Scouts. She pulled my son out of Scouts. As punishment for pleading, she would not let them attend their great-grandmother's 99th, 100th, 101st, and 102nd birthday. My grandmother is still alive in Wilton, New Hampshire, but does not get to see her only great-grandchildren at all.
So she's not seeing the grandchildren either?
She filed a motion for grandparent rights, which is also a law in the state of New Hampshire, and Marital Master Cross denied it, saying she wasn't a grandparent. Great-grandparents don't count. That's...
No. Honestly?
Honestly. I would not tell it to you if it wasn't documented. Absolutely.
Who is this, Marital Master Cross?
Marital Master Philip Cross gained notoriety in 2007 when he wrongly incarcerated David Johnson for 10 weeks.
Case. 10 weeks.
Exceeding his authority. The man doesn't have the authority to jail David Johnson, but he did, and caused the man to lose his home, custody of his children, and his job.
He's petitioner number 5. I've actually heard his case, and he will be on the show coming up soon.
And all the judicial branch did was move Marital Master Cross from the Derry Family Court to the Portsmouth Family Court, where he continues in this case.
That's interesting.
And he also, the Portsmouth Family Court is the same court that gained notoriety last year in a U.S. Supreme Court case, Miller versus Todd, which came out in April of last year.
So what brings you to the appellant, to become an appellant? Where is that in this whole process now? You're denied. You've got very limited no overnights with your kids.
Correct.
You have 3 hours a month.
Well, now he's reduced. In October 4th, his final ruling came out. Not only do we have the hearing September 9th and 10th, I get a final ruling in March of 2011, which then gives away my home, saying Miss Kenick is now established there, and therefore we're going to give her the home. I said, did you not pay attention to any of the documentation that shows he signed away all rights and interests to the house and wanted nothing to do with it? I'm the only name on the deed. I'm the only name on the registry of deeds, the only name on the bill of sale, the only name on the mortgage. How does that work? And because she has more than 50% custody of the children, he said, you shall now pay child support retroactive 15 months. I was $22,500 in the hole the day the order came out.
How much?
$22,500 the day the order came out.
And so not paying that, are you in contempt?
Absolutely. I have been held in contempt. I've been found in contempt of court, which is part of what I've appealed to the Supreme Court. I said, how can this happen?
Did you tick off the judge?
Apparently, yes.
How?
I don't know how, by not having a lawyer, apparently. But maybe it's a good boys network. Judges are all lawyers, and they all belong to the same bar association as lawyers, so maybe they don't like pro se litigants. I didn't choose to be one. I was rendered one by the court repeatedly granting delay after delay after delay over my objections.
Now, so at this point, is this when you filed your petition for a...
So right after the final hearing came out, the final ruling came out, I filed an appeal to the New Hampshire Supreme Court. Thank God the New Hampshire legislature, in its infinite wisdom, passed a law for mandatory Rule 7. Married people have an automatic right to file with the Supreme Court, and the Supreme Court must take the case.
But I thought you were in familiar status.
But the New Hampshire Supreme Court did accept the case, and it is pending. It is a public case file.
Now, you also filed a petition with the New Hampshire...
I did file a petition of redress with the Redress of Grievances Committee in the New Hampshire legislature, which was newly formed just a couple of years ago. And it's important for the viewers to recognize that that is actually a constitutional right.
Article 32.
Thank you very much. And therefore, again, the power rests with the people, the citizens of the state of New Hampshire, not with a hand-selected group of life-appointed judiciaries who wish to legislate from the bench and ignore the laws passed by the elected officials of our state and the rules of evidence and come up with the strangest rulings ever that defy logic, if anything. That is my appeal to the Supreme Court. In fact, I've filed my appeal under constitutional violations. My right to due process has been violated, which is a part of the 14th Amendment.
When will this be heard?
That's a good question. It has not been scheduled yet. I filed my brief in January. Her lawyer filed an objection in March, and I filed a reply to that objection, and now we're waiting to see if the Supreme Court will rule on it based on the evidence before them. But as you can see, it's a large amount of paperwork. or whether they will grant me a hearing before the full panel, 5-person judge panel.
Wow. And in the meantime, you'll be addressing the redress of grievances.
I look forward to addressing, my petition is in and has been since October, and I very much look forward to addressing the petition of redress. All I ask for is protection and relief from the family court, which continues to attempt to promote or promulgate the previous rulings, all of which are under appeal to the Supreme Court.
If some big shot lawyer came in and said, hey, listen, I'd like to represent you pro se, would you take it?
In a heartbeat.
Okay.
I would welcome that. I spoke with a lawyer who won a very well-known case here in the state of New Hampshire. He's an appeal lawyer. All he does is appeals to the Supreme Court. He read this documentation, or a large portion of it, and he said, Joe, your case is well documented. He said, honestly, you can win it yourself. He said, let me tell you about what actually happens. He said, in the Miller versus Todd case, the Supreme Court overturned the Portsmouth Family Court's rulings, same marital master Philip Cross, and Judge DeVries, and all that really happened is it's a giant do-over. Poor Mr. Miller still does not have custody of the 2 daughters who were kidnapped the day his order from the Michigan Family Court gave him custody of the kids.
Now, will it hurt your case if you're before the redress of grievance?
It may very well. I certainly won't make friends, but I'm not here to make friends. I'm here to let the truth be known. It is well documented, and let the chips fall where they may. I just ask for protection and relief from the family court's ability to take my driver's license, lock me in jail, or otherwise hold myself, my children, or my property hostage, or for ransom.
Joe, I'm going to have to thank you for coming on the program.
I appreciate you having me. Thank you very much.
If there's any final thoughts that you have, other than CAC 26, I want to give it a plug because I think it's, in my opinion, that is a big step forward in helping many families. And this is just males. This is males, females, grandparents.
Absolutely. I've been contacted by grandparents from as far away as Arkansas or Massachusetts who no longer get to see their grandchildren.
Have you been in touch with Judicial Child Abuse yet?
I have. In fact, I have a short video on judicialchildabuse.com. Mm-hmm. And I urge everyone who's interested in this topic to go see it. The last thing I'd like to share with you is people who may not be in divorce think, well, this will never happen to me, so why do I care about that? Because your tax dollars are funding this fiasco. More importantly, there is well-documented studies that show that taking children from their biological father has long-range detrimental effects on the children.
They are in society as a whole.
Absolutely. Right. So it is not good for society. Nor is it good for society for judges to be allowed, or marital masters to be allowed to disregard the rules of the court, the laws of the state of New Hampshire, or the constitutional rights of the citizens. And that must be stopped. The final thing I wanted to share with you is that etched in stone on the Holocaust Museum in Washington, D.C., is a quote from a man who was a Lutheran minister. And it basically says, it's a well-known quote, it basically says, when the Nazis came for the Jews, I did not say anything because I was not Jewish. And when they came for the trade unions, I did not say anything because I was not a trade union. And when they came for the communists, I did not say anything because I wasn't a communist. And then they came for me, and there was no one left to speak for me. That man was actually incarcerated by the Nazis just a year or two after being a staunch supporter. So this affects all of us. It is vitally important that it stop.
Joe, thank you for coming on the show.
Thank you very much.
All right. Thank you very much for watching Speak Up, listening to the case. If you're an attorney and you want to represent Mr. Kenick, by all means, please do.
Yes, please.
And if you're interested in sponsoring this show, please, we want to be here for you to help people speak up. And if you want to help Speak Up continue, please email me at speakupnh@gmail.com. Thanks again, and until next week.
Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandals and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up. To stand up and fight back.